So many of the things that Bob described are true about mediation as well. You save a lot of time, you save a lot of money, and it is private. Anything that happens in the mediation process cannot be discussed outside of the mediation process. We call it like Las Vegas. What happens in Vegas stays in Vegas, and you can't. There are exceptions, but for the most part, the process is confidential. And like in collaborative law, everything is agreed to before you ever file the first petition, before you file that initial document that gives jurisdiction to the court over the process. All of this is front-loaded and done in advance. How is it different? It's different in that rather than having two attorneys and the professionals direct the process, you have a trained mediator who is trained in family law, is trained in facilitating negotiations, who's neutral and impartial, generally does not know the parties or may know the parties, but feels objective about the parties. And this neutral facilitates a discussion between the parties, and the parties come to the agreement pretty much on their own. What are the major differences? When you have attorneys in the room, you can get a lot of legal advice. A mediator cannot give legal advice. What does that mean? If you have specific legal questions, a mediator can point you in the right direction, can tell you what the law is. But at the end of the day, the mediator is not going to be able to turn around and say, okay, spouse, in your specific set of circumstances, this is what I think you should do. To the contrary, the mediator will get the two to discuss it and agree to what they both think they should do together in order to remain neutral. You went over a lot of the benefits, so I'm not going to repeat it. The benefits are pretty much the same. I'm not sure you're aware, in Florida, every case is mediated before you get to a final hearing. It's something that the state of Florida has adopted. It's going on, about 20 years now in most jurisdictions in Florida? Yeah, probably about 20 years. Where if you want to get to a final hearing, a judge will send you to mediation. There are a couple of exceptions, like domestic violence cases where it can be waived if they feel it won't be beneficial to the parties, but to get to your final hearing, even if you go the traditional route, you're going to mediate. The question is, where along this continuum are you going to make that decision? And where do you get the most benefit of it? If you reach an agreement early and mediate early versus you're doing it only as that last hurdle you have to do in order to get your final hearing. Obviously, if you do it at the very end, you lose all the financial benefits of mediating early. And if you do it at the end, you also lose all that time benefit, as Bob explained. A litigated divorce can go on 18 months, 24 months, and even now with the clogged court system, longer than that. So if you mediate early, obviously you save yourself a lot of time as well. Also, if you mediate early, you save a lot of the dynamic, that toxic dynamic that saves your relationships. Very often when the mediation comes at the very end, it takes the mediator hours just to move the parties off of that angry place that they've built up for so long and get them into a place where they can actually start to realistically negotiate something that's reasonable. So the process itself will take much longer if you wait until the very end. What I do that's different from what Bob does is I work with the couples through the process with no attorneys in the room, what we call pro se mediation. I will guide them through all of the issues that they have to deal with, the parenting plan, dividing the assets, the alimony issues if they come up, the child support guidelines, all of those issues. I maneuver them through that, and they'll come up with the agreement on their own. We do everything before suit is filed, so it's what we call pre-suit pro se mediation, as opposed to mediating during the process or towards the end of the process after suit has already been filed. So, and it can be done that way. I'd say the biggest difference between what I do and what Bob does is how much every hour you spend in mediation is actually costing you. There are cases where families have assets that need to be evaluated. A lot of psychological concerns involving the dynamic of the parents or the children. Those cases lend themselves best to collaborative law. And when I get those cases, even in my practice, when I screen them, I send those cases to people like Bob, and he knows this because I've asked him. Or cases that are very contentious and one spouse already has an attorney, I will refer them out to an attorney and say, you're not ripe for mediating in this paradigm. But for cases where the parties both pretty much know what they have, they pretty much have a good understanding of what the value is on what they have, they can deal with each other even if they are still angry, and even if there's still a lot of emotion to unpack, they can go through a mediation process where I will guide them through a and anybody who does what I do, we make a point of not just getting them through the process, but also teaching them how to better deal with each other and resolve their conflicts on their own. The goal of what we do is to get them to learn to discuss it, work it out, and make their own decisions on their own. At the end of the day, when you get the final divorce, if the process was handled the way it should be, the couple is much better equipped to continue to negotiate on their own and deal with each other. And they don't necessarily need the mediator or this big great negotiation coach between them, and then they end up going back to court so much less, because for the modification, they'll pick up the phone. If they want to deviate from a parenting plan, I'm sorry, I have a conflict, can you pick up, our child instead? They learn to pick up the phone, deal with each other, make the adjustments, and make the negotiations between themselves without anybody else really helping them. Less trips to court, less money at the end.